ดีค่ะท่านผู้ชมทุกท่านดิฉันนางสาวจริญจิตพันธวีนะคะผู้พิพากษาศาลชั้นต้นประจำสำนักประธานศาลฎีกาค่ะขอต้อนรับท่านผู้ชมทุกท่านนะคะเข้าสู่รายการ COJ Smart Talk ในตอนนี้ก็เป็นตอนที่2แล้วนะคะรายการ COJ Smart Talk เป็นรายการที่จะนำทุกท่านมาอัปเดตแลกเปลี่ยนความรู้ทางกฎหมายทั้งจากประเทศไทยและก็ต่างประเทศค่ะประเด็นที่กำลังได้รับความสนใจเป็นอย่างมากในช่วงนี้นะคะก็คงหนีไม่พ้นประเด็นเกี่ยวกับสินทรัพย์ดิจิทัลซึ่งในวันที่21เมษายนที่ผ่านมานะคะเนื่องในโอกาสวันศาลยุติธรรมเราได้มีโอกาสเสวนาเกี่ยวกับสินทรัพย์ดิจิทัลที่เกี่ยวกับประเทศไทยไปแล้วนะคะในวันนี้รายการ COJ Smart Talk ในตอนที่2สำนักงานศาลยุติธรรมได้รับความอนุเคราะห์จากสถานเอกอัครราชทูตสหรัฐอเมริกาประจำประเทศไทยที่ได้ติดต่อวิทยากรผู้เชี่ยวชาญมาร่วมอภิปรายในหัวข้อกฎหมายสินทรัพย์ดิจิทัลและการสืบพยานหลักฐานดิจิทัลในสหรัฐอเมริกา Digital Asset Law and Digital Evidence Examination in the U.S. Court Proceedings ค่ะดิฉันขอถือโอกาสนี้แนะนำท่านวิทยากรทั้งสองท่านเบื้องต้นดังนี้ค่ะวิทยากรท่านแรกนะคะคุณเทรนเซนอาคาน่าปัจจุบันท่านดำรงตำแหน่งผู้ช่วยของผู้ช่วยทูต United States Secret Service ประจำประเทศไทยท่านทำหน้าที่ติดตามภารกิจสืบสวนสอบสวนโดยเน้นทางอาชญากรรมซับซ้อนทางด้านการเงินที่เกี่ยวกับไซเบอร์และประสานงานกับประเทศต่างๆในภูมิภาคเอเชียตะวันออกเฉียงใต้ด้านคดีไซเบอร์และการเงินที่เกี่ยวโยงกับการพิทักษ์คุ้มครองสถาบันทางการเงินของสหรัฐอเมริกาค่ะวิทยากรท่านที่2นะคะคุณคริสตี้เอ็นโอมาลีที่ปรึกษาอัยการด้านอาชญากรรมไซเบอร์ระดับภูมิภาคเครือข่ายด้านทรัพย์สินทางปัญญาและการแฮกคอมพิวเตอร์สำนักงานเพื่อการพัฒนาการให้ความช่วยเหลือและการฝึกอบรมด้านการดำเนินคดีในต่างประเทศกระทรวงยุติธรรมสหรัฐอเมริกาค่ะในปี 2020 ที่ผ่านมานะคะคุณคริสตี้ได้รับเกียรติคุณจากอัยการสูงสุดสหรัฐจากผลงานด้านภารกิจของทีมอัยการและเจ้าหน้าที่สืบสวนในการทลายกลุ่มผู้แสวงหาผลประโยชน์จากเด็กในดาร์กเว็บปัจจุบันคุณคริสตี้ค่ะประจำอยู่ณสถานเอกอัครราชทูตสหรัฐอเมริกาประจำกรุงกัวลาลัมเปอร์ประเทศมาเลเซียค่ะในโอกาสนี้นะคะดิฉันขอเป็นตัวแทนของสำนักงานศาลยุติธรรมขอบพระคุณสถานเอกอัครราชทูตสหรัฐอเมริกาประจำประเทศไทยและวิทยากรทั้งสองท่านที่มาร่วมอภิปรายแลกเปลี่ยนความรู้ในโอกาสนี้ค่ะลำดับต่อไปนะคะดิฉันขอเชิญทุกท่านพบกับวิทยากรของเราในรายการ COJ Smart Talk ตอนที่2ได้เลยค่ะ Okay, shall we start?
Sure.
Okay. Good morning, everybody. Welcome to the second episode of COJ Smart Talk. As mentioned today, we have the honor and privilege from the speakers as a courtesy from the US Embassy in Thailand. I would like both of them to introduce themselves once again. Please, can I start with Christy?
Sure. My name is Christy O'Malley, and I am a federal prosecutor from the United States. I've been a prosecutor for almost 11 years now, and I've prosecuted all different types of crime, including cybercrime, cyber-enabled crime, child exploitation crimes, and many, many of the crimes that I've prosecuted involve digital evidence. My role here in the region is I am a cybercrime attorney advisor. I focus on capacity building in cybercrime, cyber-enabled crime, and digital evidence throughout Southeast Asia, and that includes Thailand. And I'm based out in Kuala Lumpur.
Thank you. And Trenson, can you please introduce yourself to the audience?
Sure. Hello, my name is Trenson Akana. I'm a special agent with the United States Secret Service. I am currently here in Bangkok and operating out of the Honolulu field office in Hawaii. Kind of like Christy mentioned, my background with the Secret Service, I'm a part of the network intrusion investigation department, and we basically investigate cybercrime to include the actual intrusion or hack, all the way through the various steps of money laundering and so on and so forth. So definitely happy to be here, and thank you for having me.
Thank you, both of you, once again. On behalf of the Office of Judiciary, we are very pleased that you accept the invitation to be our speakers today. The topic of our episode in this second episode is digital assets law and digital evidence examination in the U.S. court proceedings. On the 21st of April, we have the honor of the speakers in Thai law relevant to digital assets law in Thailand. So this is a great opportunity that we can learn from your expertise, undoubted expertise on digital evidence and digital assets law in the US. Without further ado, I think we can start our discussion today. I think it's worth for both of you, either of you, to explain to us the classification or the types of digital assets in the US, and as well as the current legal and regulatory framework according to the types of digital assets in the US, please.
Certainly, I can start with that one. So when we talk about digital assets in everyday conversation, when we're not talking about legal regulation, we're usually talking about virtual currency such as Bitcoin, where transactions are recorded on a blockchain. When we think about digital assets regulation under US law, what we're really talking about is the regulation of a type of activity which governs which governmental body is going to regulate it, as opposed to the regulation of the digital asset itself. So there are a number of different US government agencies involved in different aspects of digital asset regulation. And the specific way we define a digital asset will determine which agency is involved in that regulation. So for example, regulation and enforcement can come from the Securities and Exchange Commission, the Commodities Futures Trading Commission, the Department of Treasury Financial Crimes Enforcement Network, the Department of Justice, and various law enforcement agencies such as the Secret Service, FBI, IRS, and Department of Homeland Security. When we're talking about the SEC or the CFTC, we are talking about digital assets that include instruments that qualify as either securities, commodities, or security or commodities-based instruments, such as futures or swaps. So when the digital asset qualifies as a security or commodity, then you're going to have the Securities and Exchange Commission or the Commodities Future Trading Commission regulating activity involving those. The nature of the digital asset related activities a person engages in is the key factor here on which agency is going to regulate it. So when we're talking about, as I said, something like a commodity, that's going to trigger regulation by the CFTC, and the security is going to trigger the SEC. Now, if a person or an entity falls under the definition of a financial institution, which would include a traditional bank, but it also includes different money transfer institutions or money businesses, that they would then be subject to anti-money laundering laws and counter-terrorist financing laws under what we call the Bank Secrecy Act. And in that case, our Department of Treasury would be the primary regulator for activity involving those money service businesses or money transfer businesses. So if we're talking about derivatives and derivatives markets, then the regulation of digital assets comes under the Commodities Future Trade Commission. And then if we're talking about securities and securities related conduct, and that includes things like investments and securities brokers and securities exchanges, that's going to fall under the Securities Commission. The Department of Justice comes in when we're talking about enforcing federal criminal laws, and that includes also the law enforcement agencies such as the Secret Service and the FBI. We're going to focus on when someone commits a crime involving a digital asset, then either the Department of Justice or one of those law enforcement agencies will get involved in enforcing criminal laws that relate to crimes committed with those digital assets. So, long way of saying that the regulation is focused on the activity and not the asset itself. And we regulate the activity based on how the digital asset is being used.
I just wanted to add, Darren, Chris did a great job introducing the various regulatories, compliance, and all of the different agencies. I mean, I can't even name them all, even just within the United States government. I think the important thing to remember is that you're always going to have various, when we see a crime on the street, we're going to pick it up as crime. As we take that in, work with our AUSA's office, prosecutor's office, much like Christy, we then start to figure out, who controls this, who would take this. But the bottom line is, and the U.S. government is working very hard to have this, whole of government approach to where the various agencies, regulatories, and compliance agencies are working together to focus on those crimes. So I personally am no expert in understanding, who regulates what, who controls what. But this is why working as the investigator or police officer on the street, working with your attorney's office to understand, who covers what and what crime was committed and how we can attack that type of crime and investigations is very key. And so having not only the government and the various agencies working together, but then working with the private sector, which we'll get into a little later in our presentation.
Yes, we can learn from both of you at the outset that the regulations revolving digital assets in the US mainly focus on the activities that involve the digital assets, not the types or the digital assets themselves. I think the second question then, you mentioned that the case will be referred or handled by the Department of Justice when the criminals or the criminal wrongdoings from the activities that involve digital assets. Can both of you please elaborate on the criminal laws that govern the digital assets activities to us, please?
Certainly. So when it comes to criminal enforcement related to digital assets, we really are using the same criminal laws as we use for various other types of crimes that do not involve digital assets. So again, we're looking at the activity, the criminal activity, as opposed to the means used to commit that activity. So we use traditional fraud statutes. We have a wire fraud statute that gets at the underlying fraud conduct. When we have a fraud involving digital assets, such as a romance fraud scheme or even investment fraud schemes. When we have money laundering activity, we would use our money laundering statutes if someone is laundering money in virtual assets. If someone is engaged in operating an unlicensed money remitting business and it happens to involve digital assets, we would charge them with being an unlicensed money remitter. And so, again, we're really focused on the activity. If we're dealing with a drug dealer collecting payment in virtual currency because they're selling drugs on the dark web, we would likely go after them with our narcotics statutes to prosecute them for selling narcotics. And if someone is seeking digital assets from others to fund terrorist activity, we would use our terrorist financing statutes. So just like I described, when we regulate assets, we look at the activities in terms of our regulatory authorities. The same applies when we're dealing with criminal laws and enforcing criminal laws, getting at the underlying criminal conduct.
Yes. The criminal laws that govern the digital assets activities, then you mentioned both the traditional criminal law statutes and also the U.S. Law will focus on the activities. Once again, when it involves money laundering, it will be dealt with the money laundering statutes, etc. So when people talk about or discussing about digital assets, the main concern is the fraud or the protection of investor, because it is something new and very novel concept. In your both of your points of views, what are the future best practice for fraud prevention, investor protection, and other issues that involve digital assets?
So I'll take that question, or at least the first bit. But before I do, I just wanted to piggyback on what Christy was mentioning. We have the luxury, in the United States to fall back on those traditional laws and statutes. And specifically for the Secret Service, because we have been, and back in the day, we were under the Treasury Department. And so, because we were formed, the agency was formed back in 1865. We have over 150 years of experience in investigating your traditional financial crimes. And what we've seen is basically just a transformation because of the evolution of technology to basically see from street crime, whether it be counterfeiting, US currency, credit card fraud, and then now we fast forward to some of that cryptocurrency that Christy was mentioning. And so, and we'll discuss this throughout our conversation today, but the crimes evolve, but they're basically using the same elements, and the investigation evolves basically using the same, traditional investigative methods. So, with that being said, we are fortunate, and again, United States is tweaking their law, as we speak, to to combat some of these evolutionary crimes. But it's nice to have that traditional crimes in place so that we can still, like Christy mentioned, charge on bank fraud, wire fraud, computer fraud, some of those statutes that's been around for quite a while. Now, jumping back into your question in terms of best practices, this is actually, again, my role being overseas, I would say majority of my time is spent in speaking to this very question. Best practices for fraud prevention. How can the investors protect their assets? And some of the issues that we encounter. The first thing I like to tell everyone is that it's best to do your homework, to understand some of the threats that's out there, which is why, as Secret Service, we do provide training, we provide presentations, not only to the public and our overseas partners, but also to the private sector, to ensure that they understand the type of current trends and crimes that are out there. And so the first item is, again, just having awareness of the type of crime that's out there and having operational security. And that means, for public and private sectors, to ensure that you are safeguarding your networks, but your personnel, the people who are actually accessing the internet via devices, around your organization, is to make sure that they are being careful and that they're not just, clicking on a random link or an attachment in their email and inadvertently allowing the suspect or the criminal actors to download malware and then take control of their networks. The other thing I wanted to mention is that, again, me being a network intrusion agent and combating hacking, unfortunately, with the business that we're in, it's incident response. So a lot of times, I have the duty to respond to a victim who has already been hit with ransomware, who has already been hit with business email compromise, and they've already sustained a huge amount of loss. And so a lot of times our investigations is tracing efforts or reacting to the criminal actor, whereas we're trying to flip that role and trying to educate both the public and private sector in areas to where we can prevent, those incidents from happening. And that, the best way I can recommend to a lot of the organizations that we deal with is to be prepared, to actually go through and create an incident response plan prior to the incident actually occurring, because we all know one way or form, we're all going to be victims to fraud. So we need to be ahead of the curve. We need to put in some preventative measures and actually create an incident response plan. And the incident response plan, should be very detailed. It should be, what would happen if this happened? who would we contact? What type of law enforcement or private sector companies would we engage with in order to combat the intrusion and the fraud that we see nowadays? And so I think it's important that we do our due diligence and companies do their homework. Government agencies take the preventative measures to create this incident response plan so that when it does happen, and it likely will, one way or another, that we're prepared to combat that illicit action or malign influence towards our organizations and our networks.
And I would just add on that for the investor-specific question, when you're an individual considering and investing in virtual assets, that you ask certain questions and be leery of certain representations. For example, if someone approaches you and guarantees a high rate of return on your investment, it's probably too good to be true. So the sort of adage we have is, if it's too good to be true, it probably is. So if someone's promising you a 15-20% return on your investment or higher, 50% return on your investment, and it happens to be investing in the newest digital asset that's on the market or the newest virtual currency, it's probably too good to be true. And so that's the number one thing. If you're getting an unsolicited offer, whether it's coming by an email or coming from somebody you don't know, that's also a red flag. If you're getting a lot of pressure that you have to buy today, you don't have time to think about it, they want you to buy immediately, that's a big red flag in terms of investments, generally, but certainly in the emerging virtual currency market. And then, we do have means to register investment firms, through the SEC and other entities. And so if you have unlicensed sellers or unregistered, investment firms, that's something to be leery of. You want to make sure that you're doing your due diligence on the company or purported company that's offering the investment. Do your homework, as Trenton said, to make sure that you're comfortable with the entity that you're trying to do business with.
I think both of you have shared to our viewers the law enforcement perspective on how to prevent fraud and to verify transactions. So very useful. I think the follow-up questions from the previous questions, I would like both of you to share with us what is the protocol for the proof of ownership in digital assets to verify the transaction in the digital evidence examination so that we can be the baseline question for our digital evidence examination later on.
Sure, I'll start off with that one. It's important, and like I've mentioned, the way investigators carry out the investigations, it really hasn't changed, right? The players might change, the methods, and some of the instruments or tools that we've discussed definitely has changed. But we normally like to rely on your traditional investigative methods. And even though a lot of people, get intimidated when they hear cryptocurrency or, ransomware or various malwares that are out there, I try to bring it down to a conversation that everybody is comfortable with. For example, if you're in a house and someone breaks into your house, or you have fears of someone breaking in, you lock the door, you put it, in a security alarm. And essentially with cybercrime, you're basically trying to safeguard your network, which is the internet, and your devices and that connect to the internet. And so putting in protocols or a security alarm, much like a firewall, is very important. Locking your door, making sure the windows are locked, is also very important. And that's basically training your employees, the people that actually log on or connect to the device and then go out on the internet, is taking the preventative measures and using two-factor authentication and all those various security measurements. Now, with the proof of ownership, just like your traditional investigation, we also use, areas that can actually lead us to what we call attribution, or the actual person that's either committing the hack or participating in the criminal activity in furthering the money laundering vector or aspects of the investigation. And I think a key word that's important to remember throughout a cybercrime investigation is cyber-based selectors. So much like a crime scene where you have various evidence that you can actually leverage, a cybercrime has the same, and that cyber-based selectors could include, suspicious IP addresses. It could include email addresses. It could include various services that the criminal actor may have used that we can then flip and start to work towards attribution, or actually use in our favor to start to investigate and get towards the malicious actor in these various types of cybercrime. And so I think it's very important that we look at the proof of ownership in digital assets as also being able to translate and take some of what we're used to investigating and using it, but understanding the terminology and methods in basically investigating some of the criminal actors. I mentioned IP addresses, maybe device that they've used, that we can then go back and find the actual criminal behind the crime being committed. But there's also something to say about behavior analysis as well. And this is something, when we start to get into cryptocurrency, is actually relied upon pretty heavily, in terms of watching various, criminal behaviors, watching how they move the money, how they actually hack into various systems, and what methods they use, what malware they use, what variants they use and strands in trying to further their crime. Those are all things that we can actually identify and then start to attribute towards proof of ownership. But I'm going to turn some time over to Christy, because I know she has, from the prosecutor end, some keys on proof of ownership as well.
I would just note that in terms of trying to attribute the digital assets to a particular target, our investigations often start with blockchain analysis, which is every transaction that happens with Bitcoin or other virtual currency is recorded on the blockchain, and it's public and it's available to everyone. And there are websites where you can go and see every transaction that's ever happened, for example, with Bitcoin. And so you have the entire ledger, you have all of the transactions as a starting point. And then, inevitably people want actual fiat currency, real money that they can spend. And so at some point, they're going to transfer that digital asset or that virtual currency into real money, and often rely on virtual asset exchanges or other types of businesses that have know your customer requirements and other information about the individuals using their exchange services. And so we look for those cash out points, and other information that the exchanges have to try to start identifying who the individuals are that are conducting particular transactions. And that's just one of many investigative, leads that we follow. As Trinson talked about, we use our typical cyber investigative techniques to find anyone that's doing activity on the internet. The only sort of unique thing when we're dealing with virtual asset transactions is that we also are doing that follow the money virtual asset analysis on looking at the blockchain as a starting point.
All right. I think we some of our audience, I think they are keen to learn from you. There's some examples or case studies that are involving digital assets that can be classified as cybercrime. So I don't think it's typical cases in Thailand right now, but I think it's emerging trend as you mentioned. So if you can share with us from your experience or from your from when you're in your office, you're doing your duties, please.
Sure. Again, some case examples, case studies. Um, like I mentioned before, the times are evolving, right? People are now using options, be it with their finances, with a lot of their work and their day-to-day duties, where they're actually favoring convenience. And again, we live in a time where everything is convenient. We must have it, immediately. Um, and it's all about the bandwidth, and it's all about the speed. And the quicker we can do things, the better off we are. Well, unfortunately, with that comes vulnerabilities. And so, the current trends and crimes that we're seeing now is basically feeding off of the need for convenience, and people want it quicker, faster, as opposed to more genuine transactions, as opposed to taking this time to ensure that their finances, in this case, is secure. And so, one of the cases I wanted to bring up, um, where we had an informant, basically in the dark web, um, and we had intel that there was credit cards that was being sold, um, stolen from the victim, credit card information that was being sold on the dark web. And so we basically took that information and did some transactions um, with the criminal, and found out through those transactions that the criminal was wanting to be paid out in Bitcoin, again, a cryptocurrency. And so we continued the investigation, and as we dealt with the suspect himself via the dark web, we were able to, again, like I mentioned, pull some cyber-based selectors, identifiers, not necessarily the actual individual himself, but we were able to pull some moniker or usernames that the individual used. We were able to monitor his behavior. We were able to identify, like I mentioned, a Bitcoin address, that public key, and like what Christy mentioned, that's public ledger, written on the blockchain, that's accessible to the public, and something that can never be erased or taken off the blockchain. We start to use those avenues and information to get towards the criminal. And actually, in this particular case, we were able to leverage some of those cyber-based selectors, be it monikers, email addresses, definitely the Bitcoin public key or address, and we were able to actually identify our suspect and an actual person. And so with the Secret Service, because we understand the importance of the money laundering vectors and how these financial crimes have, historically gone, we can now bring that fast forward to the future and do the same with cryptocurrency. I mean, we take pride in following the money. That's what we've been doing for over 150 years as an agency. And we've leveraged our existence with the Treasury Department to become experts in financial crimes. And so, taking that experience, we basically follow the money. Now, we follow the money because even nowadays, that's why criminals are doing it, right? I think the biggest crime on the dark web dealing with cryptocurrency is for illicit gain and financial crimes. And that's the main reason why they do it. So if they're doing it, then we follow that money, and then basically we take an anonymous platform, a pseudonymous platform such as cryptocurrency, and strip away all of those cyber-based selectors to essentially identify the criminal actor's true identity, and that's just in a nutshell how we go about doing our investigations.
And just adding sort of at a higher level, the types of cyber crimes that we see committed with cryptocurrency. Just wanted to make the point that pretty much all criminal activity that happens on the dark web is going to involve payment in cryptocurrency, and the reason for that is because no one's going to ask you to pay with a Visa card or another credit card that's easily traceable. They asked for payment in cryptocurrency under the thought that it's harder to track, for law enforcement. So you're going to see lots of criminal activity on the dark web involving payment in cryptocurrency. You're also going to see legitimate transactions with cryptocurrency that aren't crimes, but pretty much every cybercrime and cyber-enabled crime can be committed with cryptocurrency. We see a lot of, for example, child sexual abuse material being sold on the dark web and asking for payment in cryptocurrency. We see drugs being sold on the dark web, asking for payment in cryptocurrency. We're seeing more and more ransomware, cases where you open your computer one morning and all of a sudden you have no access to your files. You're a big business, and and you're told, here's the Bitcoin address where you need to make the payment in cryptocurrency in order to get the decryption key to get access to your files again. So pretty much any type of crime, can be committed with cryptocurrency. We've seen romance scams where ultimately, someone will be asked to open, set up a Bitcoin wallet and, put some money and transfer it. Business email compromise, the same thing. So it's an emerging, form of payment that criminals are starting to use in lots of different types of crime and lots of different types of, traditional cyber crime that we see.
Also, I just wanted to add on that, and I've shared this with JTI throughout our presentations previously. I just want to comment that the three biggest, at least, cyber threats and crimes that we see, and it's actually, not only in the United States, globally, but it's also specifically here in the region. Like Christy mentioned, if I was to put the top three, it would be ransomware, business email compromise, and then phishing activity. And phishing activity, it basically covers the entire gamut. Elderly abuse fraud, romance scam, or just getting, an email that, these criminals are sending to hundreds of thousands, if not millions of people, hoping that one of them will go and click on, again, a link or an attachment that will download malicious malware and basically infect your computer. And so, those are probably the current trends that'll probably be around for a while. But Chris is exactly right. They're not going to ask you to meet you, at the mall or at a parking lot at Big C and actually transfer cash. They're also not going to ask you to pay to this, debit account or financial institution account. They're going to use cryptocurrency, and that's the main reason why, right? They want to try and obfuscate their true identity. So that's the main thing. I think the other piece I wanted to add is, with all three of those trending crimes in cybercrime, every single one of them is just a vector into your networks. In other words, a means to hack into your computer and then to get to your financial information or even your private data, which should be secured. So with those, like what I like to call vector points, everyone does need to take the proper security measures in ensuring that their agency, organization, corporation, company has the proper security measures in place. And that's why it's important to have, a background in some of that cybersecurity implementations.
I think we have spent quite some time on the activities involving digital assets and mainly focus on the criminal activities that lead to the case studies that you mentioned on cyber crimes. I think inevitably, I think our judges and judicial officers, they would like to learn more when those kind of cases in the future that come to the court, how the court proceedings involving the court cases on digital, even the digital assets or cyber crimes that they will have to be conducted in our court. I think we will then move our discussion on the digital evidence examination. The first question I would like to put to both of you is that what is considered as digital evidence under the US law or the US jurisdictions, please?
Sure. So when we talk about digital evidence in the United States, we use it broadly to cover any form of evidence that is transmitted or stored electronically. And I'll give you a bunch of examples of what I mean by that. So digital evidence includes any data that's found on computers, mobile phones, other electronic devices, storage devices such as thumb drives, DVDs, CDs, hard drives, or other external storage devices. It also includes data stored on the internet and any intranet, which is a closed computer network, any server, any social media or email accounts, or any type of cloud storage. And it extends to what we call the Internet of Things, where you have computing devices embedded in everyday objects that can send and receive data over the internet. We have smart refrigerators now, we have smart watches, we have security devices that connect with the internet, we have Amazon's Alexa that you can talk to and tell to do things that people have around their houses. So any things that connect to the internet. And digital evidence also in the digital asset space includes the blockchain data. So it's a very broad category, but it's really anything that's electronically stored or generated. We have specific rules of evidence that allow, and we'll talk about this in more detail in a little while, but specific rules of evidence that allow emission of certain forms of digital evidence without calling a witness if the evidence is accompanied by an appropriate certification. For our rules of evidence, we focused on records generated by an automated electronic processor system that is demonstrated to produce an accurate result. So any computer-generated evidence, and also data copied from an electronic device, storage medium, or file when authenticated by a process of digital identification, such as a hash value, which we'll talk about later. So that's what we mean when we refer to digital evidence. And like I said, we'll elaborate on how we treat it in court as we go on.
And in follow-up questions from the previous question, in what ways are digital evidence in the US significantly different from the traditional or the material evidence that we usually presented in the court? And what are the similarities and how can this affect the court proceedings in your opinions?
So in terms of digital evidence, sort of differences and similarities, they're really in many ways the same. And what I mean by that is that we introduce them with the same means. We rely on either direct evidence or circumstantial evidence when we're introducing traditional evidence, like a piece of paper from a file, or when we're introducing an electronic copy of that file. So in terms of our rules of evidence, in many ways, we treat them exactly the same. We ask, is it relevant? And if it's relevant, is the probative value substantially outweighed by the prejudicial impact of admitting that evidence? And then we look at whether or not it can be proved to be authentic and reliable, which we'll elaborate on in a little while. But really, we treat it as the same thing. We have the same problems when we're talking about digital evidence. We are looking at, as we are with traditional evidence. can be faked, it can be altered, it can be contaminated. You might have chain of custody issues, but that's not unique to one type of evidence or the other. And we also have the same solutions when we look at these different types of evidence. To introduce the evidence, we call a witness with personal knowledge. We might look at distinctive characteristics of the evidence. We look at the process or system that generated the evidence. And ultimately, the court is looking at weighing the admissibility of the evidence versus the weight to give the evidence in any given proceeding in the United States courts. So often, the threshold to admissibility can be rather low, but then how much weight that evidence is given will depend on how reliable the evidence is in the court's mind based on the evidence presented. And so in many ways, I find digital evidence to be far more reliable than other forms of evidence because everything you do on the computer and online leaves a digital fingerprint. So any small alteration to any file is going to change the characteristics of that file in a recordable way. Every file and every device can generate what's called a hash value, which is like digital DNA. It's a unique mathematical algorithm of letters and numbers that can be generated for the file. And it's a computer program that generates that mathematical algorithm. And it is, millions or billions of times more reliable than DNA. And so if you change one letter in a document, it would generate a completely different hash value. It would be totally different. And so you would know that it had been altered. The same thing in a picture, if you change just one pixel, like the smallest thing where you can't even see it with the human eye, it's going to have a completely different hash value and you're going to know that that file was altered. We also have, when we're talking about evidence recovered from digital devices, such as photographs or that we take with our smartphones, for example, you have metadata embedded in that photograph that tells you the time and date it was taken, the type of device, things that are computer generated. And you can tell if those have been altered because of the digital fingerprint that's left with electronic devices. So I love getting electronic evidence and being able to admit it in my cases because I feel like the judges in the United States often rely on it more than having to trust the credibility of a witness or a piece of paper that somebody printed that they could have doctored in some way. The digital evidence leaves much better traces. In terms of admitting the evidence, we either admit digital evidence as self-authenticating because it's the product of a computer-generated process that has been proven reliable in the past, or we would call an expert witness, such as a forensic analyst, to testify about the evidence, just like we would call a chemist to prove the chemical components of a particular drug. So when we're talking about a digital examination of a computer or a phone, often we'll end up calling a forensic analyst that will provide testimony based on their experience and expertise that will tell us that we can rely on what is on the digital device. We also can rely on proven reliable programs, such as Cellbrite and other programs that analyze mobile phones that have been proven reliable over time by continued use. And so if the extraction comes using one of those tools, we know that it doesn't alter the data on the phone, it just extracts the data. And so you can rely on the report that is produced from those tools that are constantly validated and confirmed to be reliable. So that's one of the ways that we admit digital evidence, is just relying on those tools. When we get evidence from, we also get evidence from search warrants, for example, from a social media company or an email company. When we get that evidence back in response from the company, when we issue the search warrant to them and they give us the evidence back, it comes with a certification that says, this evidence is reliable because we just pulled it off of our server, and our server stores the data in a format that cannot be altered. So they just pull the data from the server and they provide it in response to court process. And they have no stake in the case. Like, an individual company doesn't care one way or the other, right? What happens in the court case. So when we introduce that evidence that comes from the company along with their certification, that's another way that the court can rely on the authenticity and admissibility of the evidence as something that's reliable.
I think it's interesting. One point that you mentioned, you actually prefer digital evidence than the printed form of evidence. But in Thailand, sometimes we kind of have the situation of the hybrid evidence. In your opinion, how was the digital evidence, for example, the call log, transaction logs, or video clip presented in real court cases? In Thailand, we usually printed it out and introduce it in digital evidence in form of papers. I got this question by my colleague who is a practice judge in civil court, and he was really keen to learn the US experience on this.
So it's not very different in practice. Typically, what we would do is we would get, for example, let's take call logs. We would get the call logs from the cell phone company through issuing legal process to them that has to be, approved by the court. They would send all of the call logs to us. And then in terms of actually introducing it in court, I would do it one of two ways. I would either print it out and provide the paper copies of those records or the select pages that are actually useful in the case, because sometimes we can get 500 or 1,000 pages of call logs and only 3 of them are relevant to the case. Or I would show them on a screen through a trial presentation software. So, but even if I show them on the screen and say, Judge, here's page 3 of these call records, it would come with a certification from the company that says, these records came from the company. The court relies on me as an officer of the court that I'm not, trying to introduce something that didn't come from the company, that I'm actually introducing, legitimate evidence based on the certification from the company. And then we would have a paper copy that would be officially admitted into the record and stamped by the court as an official exhibit. So not too different. We often are presenting more and more evidence electronically and even giving the court a disc with all of our exhibits instead of giving them paper copies of all the exhibits. But we ultimately are either providing a file with the records or providing a paper printout of the records in the same way that you're dealing with.
The leading follow-up question from that is on the admissibility of digital evidence. So what are the factors that determining the admissibility of digital evidence? And if the digital evidence itself is acquired in an unlawful manner, or even without the consent of the owner, how does, in any way, if it does, affect the admissibility of that evidence?
So on the first question, in terms of factors of admissibility, the determination of admissibility of digital evidence is the same as the determination of admissibility of any other kind of evidence. So we follow our rules of evidence for introducing evidence. The first question is it relevant to the case? If the evidence you're trying to admit is irrelevant to the proceeding, then the court will deny admission of it because no one wants to spend weeks listening to evidence that's not relevant or reading evidence that's not relevant. If it is relevant, then as I mentioned before, we ask if the probative value is substantially outweighed by the danger of unfair prejudice. So it could be relevant, but it could be incredibly prejudicial, unduly prejudicial to the point where it should not be introduced. So that's a factor that the court considers. And then we also have to prove for every type of evidence, digital evidence or not, that it's authentic, that it is what the proponent says it is. And there's many rules in our evidence code that govern the authentication of evidence. And so when we're talking about digital evidence, you can have, as I mentioned, self-authenticating evidence when it's generated by a known, a recognized and reliable computer process, or when the process for extracting it is basically just copying, a digital file. You can now admit that with a certification without having to call a witness. But you can also call witnesses to authenticate records as well. Or we have certain exceptions where we don't have to call witnesses, such as business records that are kept in the ordinary course of business. We can get a certification and admit those without a witness. So you have to have some means of proving that it is what you say it is, whether it's a witness or a certification. And then To the second part of your question, if digital evidence is obtained in an unlawful manner, for example, if the police sees somebody's phone and start just looking through it without any search warrant and without the owner consenting, then that evidence would not be admissible in court. So they may get the phone and they may see all kinds of evidence of, someone committing a crime, but if they didn't go through the proper process, the court will reject that evidence and not consider it as part of the case. There are certain exigency exceptions in obtaining any kind of evidence, but the general rule is that you have to, as a law enforcement agent, if you want to seize somebody's digital evidence, whether it's a device or a digital account, you first have to go to a court, submit a written affidavit, and the written affidavit has to indicate why there is probable cause to believe that that device or account will have evidence of a crime in it. Then the law enforcement agent goes before a United States magistrate judge and has to swear under penalty of perjury that that evidence in that affidavit is true. And the judge decides whether there is sufficient probable cause to issue the warrant or not. And the judge is considered what we call a neutral and detached third party. They're part of a different branch of government. They have no stake in the case at all. And they based on the facts represented in the affidavit, make a determination about whether there is enough to believe that there's evidence of a crime in that particular account or device. We have a check on the power of law enforcement or prosecutors in that the court has to sanction before you make that kind of intrusion into someone's privacy, whether it's their account or their device. Now, you can also get the consent of the owner. If the owner just consents, says, yes, you can look at my device, that's sufficient as well. And we tend to like to get that consent in writing. So we tell our law enforcement agents, as prosecutors, I tell a law enforcement agent I'm working with that if the target that you're talking to says, yes, you can look at my phone, you better have them sign a piece of paper saying that before you start opening the phone and looking at it. But I also want to make the point that law enforcement does not have to get the consent of the owner to get the evidence. They can go to the court and get a search warrant, even if the owner refuses to give consent. So it's not, consent is not a requirement, but it is an alternative means of being able to look at or obtain the evidence.
So basically, the traditional rule of admissibility of any evidence still govern the digital evidence, whether it probative value, chain of custody, or authenticity. I think Transon can share it at this stage. We've heard on the court proceedings stage, on the prosecutor side stage. Can you exemplify the major problems based on your experience usually encountered by investigators when they either examining or analyzing or even collecting the digital evidence? Absolutely.
Actually, I mean, and you guys have had a great conversation regarding digital evidence, and obviously Christy, is the expert in that. And I just wanted to point out a couple things and then transition into that question. The main two things, again, as an investigator, that you need to be aware of is one, you need to be cognizant of the types of resources of digital evidence that you have throughout your investigation. Much like criminals are taking advantage of technology to basically hack into your systems or take advantage or steal or commit fraud from you, investigators, police officers, detectives, agents need to understand the type of resources that they have to attain digital evidence and use those technology vectors to their advantage. That's the first thing. And especially since we live in a world now where, again, back 10, 15, 20 years, you may be lucky to have one computer device and an internet dial-up in your house. Whereas now, there's upwards of 15 to 20. I think in 2019, they said the average was upwards of 20 in each household. But now we have, little children carrying around cellular devices, smartphones, gaming consoles. And so now you just, again, as an investigator, you have a plethora of options in attaining digital evidence. The second piece I wanted to bring up was, and much like Kristen mentioned, as important as it is to leverage those resources, we have to be careful as investigators to ensure that we are doing due diligence, um, using proper chain of custody procedures to ensure that we can actually take that digital evidence and then be allowed to admit it into court, so that we can prove our case, so that we can essentially tie a criminal actor to the time, to the place, and to the crime that was actually committed. So, and sometimes that can be tricky. It takes a lot of experience, takes a lot of training, but it's definitely doable in the sense that we should be able to leverage every single bit of digital evidence, especially as relevant as mobile devices, like Chrissy mentioned. Um, the amount of information and evidence that we can gather from that alone is actually pretty amazing. So, with that being said, obviously, like you mentioned, there is some struggles, some issues that we encounter, and I want to piggyback off of what Christy mentioned in terms of consent to acquire or a legal process that we go through in order to request information. So, much like your normal investigation where you rely on a witness, or an eyewitness or someone's testimony to witnessing a crime, in the cybercrime world, in the digital world, we leverage, like Christy mentioned, we subpoena or we request information from service providers, and those service providers act much like an eyewitness or a witness, to where they provide irrefutable or self-authenticating data and information that would provide us investigative leads throughout our investigation. So acquiring that consent is critical, and I gotta kind of back up what Christy mentioned. As a federal agent, that's probably the most important thing. Obviously, there's times where we will need to go the legal route, where we would need to process subpoenas and complaints and swear before a judge. But at times, the best way is to gain, like I said, if the victim was hacked, we gain consent to look into their computer and their device. And having their signature, their statement, allowing us access is huge. So as an investigator, it's important to ensure that you get either the consent or the legal process, so that you can gather that information, digital evidence, so that you can then admit it into court. Now, with that being said, I think one of our biggest struggles, one of our biggest problems, is the fact that because of the evolution of technology, a lot of our crimes are transnational organized crimes, and it's also cross-border types of crimes that poses another challenge for law enforcement, because as you cross the border of your country and start to work international cases, there's so many considerations, there's so many red tape, there's so many different even laws that you have to abide by. And that's what I'm learning, just being here in Bangkok for almost 2 years. I'm learning to deal with not only Thai laws, but regional laws, in Singapore, Vietnam, Indonesia, let alone the United States and some of the other countries that we deal with. And so having not only a common knowledge about some of those laws, But going back to that public-private partnership that I mentioned, being able to collaborate with the Royal Thai Police and their Cybercrime Investigation Bureau, or any other law enforcement throughout the region, is critical, because again, now you're leveraging the experts, the people who understand the law, um, and can actually assist in ways on how we might preserve. And that's, I know, Christy, um, has a wealth of knowledge regarding preservation, especially with that cross-border challenge. So that's definitely one thing I wanted to point out. The other thing is the acquisition overload piece. In the analysis of digital evidence and digital forensics, I think it's true for any agency, any department, um, you know, regardless of where you're at. You always have the struggles of having the proper expertise to examine and to attain digital evidence, dealing with the staffing issue, to where a lot of times they just feel like there's just not enough staffing or resources to tackle some of these, you know, overwhelming loads and loads of phones, iPads, computer, laptop devices, the whole gamut. As they start to stack up, it takes a lot of time to go through this. And then the third thing is funding. I think every agency department will say that, yeah, those are the some of the challenges that you face. One thing I want to mention that would actually touch on all three of those challenges that we can consider is the acquisition overload. And Chrissy and I, we always discuss this, again, as an investigator and an attorney and prosecutor. We're always used to the traditional way of, we got to work hard, we got to make sure we do everything. But nowadays, especially with cybercrime, we have to work smarter, not harder, right? And that's huge when we talk about digital evidence. And I'll give you an example of that overload challenge. A lot of departments like to go in on a search warrant and basically include every device, every flash drive, every little bit within their search warrant so that they can just take everything. Well, the problem with that is, again, if you take every single device, you got to comb through every single analysis of that acquisition, and it takes time. I mean, anybody who does digital forensics can tell you, especially with the mobile devices that we have, it can take a long time. And so, an example of us working smarter, not harder, was when I was back in the Honolulu, Hawaii field office. I was working with the Homeland Security in one of their investigations dealing with child exploitation. And, talk about a crime that deals heavily with digital evidence. But I was able, and they asked me to go along with them because of my expertise in the cyber world. And so when I went alongside them, even though they listed all of the devices, as soon as we went in and cleared the house to ensure it was safe, I was actually able to patch into the network. And within a couple minutes, I was able to outline every single device that was actively connected to the internet, every single device that was once connected to the internet. And basically, I go throughout the house, even though there were multiple families living in this house, I was able to identify all of the devices and then pinpoint the actual devices that was tied, to the suspect in this case, but also devices that he had access to and ownership, and to ensure that we were, one, just taking information that we needed, and that we were lawfully able to take, do forensics, and then admit into the court. But essentially, we walked out, even though I think I identified, over 9 devices, we walked out with 2 that was specifically tied to the suspect. And then taking it back to forensics, they were overjoyed because, again, combing through 9 or 10 devices versus 2 devices, and then pinpointing where you wanted to look at for digital evidence is a huge difference. And so that's a piece where, again, I would say, especially throughout the judiciary system, be it judges, the prosecutors, or at the investigative level, we definitely need to work smarter, not harder, specifically as it deals with digital evidence.
And I would just highlight a couple of things that Trenton said. Sort of the key challenges, definitely being smart about targeting which devices is key. It can, forensic analysis can take, weeks, or it can take months, or it can take years, depending on how many devices we're asking those forensic analysts to evaluate. And so the better we make preparations up front and be smart about it, the better we can deal with that reality. And then the other thing I would highlight that Trenton noted that is a huge challenge for all of us is the cross-border nature of the crimes that we're dealing with. And so many of the companies that are outside our jurisdiction, or that don't keep data, or that refuse to respond to law enforcement requests, in different places in the world, that's certainly a huge challenge. We have jurisdiction over the companies in our own country, and can get court process to compel them to respond to get certain electronic evidence. But that becomes much harder when you're dealing with companies outside your own country and your own jurisdiction, where you may not have legal authority to compel them to do anything, and you're relying on mutual legal assistance processes or your relationships with law enforcement or those companies themselves to try to acquire that evidence. So those are, I agree with Trenton, probably some of the biggest challenges we face in this digital evidence world.
Yeah, I've learned a great deal on the challenges and the difficulties faced by the investigators as well as the public prosecutor side. For our judges side of view, I think the main concern here is how can we be sure on the authenticity of the digital evidence obtained or presented by the lawyers of both parties. If both of you can elaborate on how can the court prove or be assured of the authenticity of the digital evidence presented by the parties, and how can the court be certain whether such obtained evidence has not been altered for fraudulent purposes, for example?
Certainly. So generally, to assure the court of the authenticity of digital evidence, as I noted before, we're relying on the same principles of proving authenticity as we do for any kind of evidence. So we prove authenticity in the United States of any kind of evidence through a number of means. One is we might call a witness with personal knowledge. We might look at the distinctive characteristics of a particular piece of evidence, whether digital or not. We can compare the evidence that we're trying to admit with other evidence that's already been proven reliable, or we can rely on processes or systems that have previously been proven reliable. And I'll give a couple of examples of what I mean about how we go about doing that. For example, if I want to admit a text message in court, there's a few different ways of going about doing it. First, I could call one of the parties to that text message exchange. So it could be the person that was having a conversation with the defendant who's on trial, for example. And that person on the other side of the conversation can testify that, yes, I sent or I received this particular text message. I recognize this as something I sent or received. That's one means of evidence that we could rely on, a witness with personal knowledge. Second, we could submit an electronic extraction of the text messages that were obtained using a program, such as Celebrite is a common cell phone extraction tool that has previously been proven reliable in the extraction of data from mobile devices. And the program is designed in such a way that it only extracts data and doesn't alter that extracted data. And the tool has been validated many times, and so the court can rely on the tool that it's not altering the data. If we're talking about, for example, trying to admit something from a website that's on a public website, and someone tries to admit a printout of something off that website, we might rely on the distinctive characteristics of the printout, such as there's a web address header and a date. There's a recognizable logo on the particular website. and other distinctive verifiable characteristics. So we can look at those distinct characteristics, just like we would, for example, with a gun with a serial number and other distinct markings on that gun. We would look at the distinct characteristics to admit that piece of evidence in court. So that's something we can look at with digital evidence as well. There might be a particular way that people communicate in email. And so we have an email that we've already proven authentic, say with a witness with knowledge, and we want to admit a second email that has a particular type of typing or speech. We might at least circumstantially be able to argue that it is by the same person, given the distinct characteristics. When we're talking about evidence from social media accounts, typically our process in the United States is to get a search warrant to get the contents of that account from the service provider, who then pulls the data from the server and has no personal interest in what the data says or doesn't say. And so you can rely on the certification coming from the service provider that the evidence was stored on their servers. But again, you could also call a witness who, saw that particular Facebook posting, or you could look at the distinctive characteristics, or their photographs of the individual. You don't have to, a photograph speaks for itself. If we pull it off the internet or if we print it from film in a camera, either way, it sort of speaks for itself. So those are some of the ways that we authenticate digital evidence. It's really following the same principles that we use with any other kind of evidence.
Yeah, I also wanted to add, so, like Christy mentioned, and she had spoken about it earlier, in terms of the hash value and how reliable that is. And whereas generally, the courts will allow DNA and rely on that as identifying measures admissible in court, the hash values are so much more reliable. Like Kristen mentioned, it's self-authenticating in terms of, it's probably zillions times more reliable than your DNA. And so, it's an opportunity, especially for investigators, to step back to understand the importance and the resources that you can pull in working a cybercrime case. But even more so, it's important for us to understand the chain of custody and basically valuing that digital evidence and treating it as such. And a lot of people might question, well, how do you, if you have an evidence, like, for example, a weapon in a murder scene, you basically use the chain of custody, you admit it into your evidence lockers or vaults that departments might have. Well, we do the same, when we go out and, conduct an incident response and acquire an image of the server or the device. The first thing we do, again, after getting consent and acquiring the image, the first thing we do is basically create a copy, and that copy, has to match the hash value as the original, to ensure that there's not even, like Kristen mentioned, a period or even a space bar or anything different where the file has been altered. That hash value will not match up. But if it does match up, again, it is genuine and is valid, and that's something that we can admit to the court. That copy of that image is then stored, as evidence, and then we produce that working copy, or even create another image, again, ensuring the hash value is correct, and then use that as a working copy. And there's tools and resources that we use to ensure that we're not, degrading the integrity of that evidence, probably more so than we would do in your traditional investigations, to ensure that it's authentic as well as admissible in the long run, to ensure that we can then use that in the court of law to prosecute the criminal actor in the case. And so, it's very important. But again, I think the more you understand digital evidence and the more you understand cybercrime, it's really a breath of fresh air in terms of the types of evidence that we can uncover, bring to the prosecutor that can eventually be admitted against the criminal.
And I would just add that documentation is key. I mean, so we were able to present to the court either in document form or through witness testimony, documented steps of every process we took. And so from the seizure itself, who had custody of it, to where it was stored, to which forensic examiner analyzed it, and then the forensic examiner documents every single thing that they do with a device. For example, we compare the serial number to make sure it's the same device that was seized, and that's documented. There's the process of copying, extracting an image of the data from the device is documented. So I think that documentation helps also, provide some comfort to the court that the evidence wasn't altered and that there was an actual process in place through that expert testimony or through police officer documentation of the steps that they took.
Yeah, that's a great point, Christy. And along that same lines, as silly as it may seem, even a lot of the acquisitions that we go out when we do an image on, an infected device or server, we also, take a picture of the device, server, computer room, even prior to putting our hands on it. Even though we have consent, we take a picture before, we take a picture as it's analyzing and acquiring data from the device and network, and then we take a picture after. I mean, like Christy mentioned, documentation is so important, and it's something for our agency that we ensure that we're doing our due diligence so that we can't be questioned later on how we were able to acquire digital evidence. And it's something that the prosecutor's office, the United States attorneys, definitely keep us honest and ensure that we're taking those steps, because again, the last thing we need is the most valuable evidence to be thrown out of court because of a silly mistake made on the investigators, detectives, or officers, hand in things. And so that's very important. And like I said, I mean, it's monumental once you start to understand the types of digital evidence that you can leverage within your case.
All right. I think on our episode today, we have learned a great deal from your expertise, valuable expertise. I think the running theme to our discussion is this, that the times are evolving and the pace of technology is evolving as well. And how the law, the legal framework, the legal practitioners are keeping up with such pace I think it's indeed pretty much relying on the awareness and the knowledge of the digital evidence or digital assets that we have mentioned before. And today we have learned from your expertise, whether as law enforcement, as prosecutors, or investigators on the digital evidence. We have touched on the admissibility of digital evidence, how the court can critically analyze or examine the relevance, the authenticity, the integrity, as well as the reliability of digital evidence. And then we have also talked about the digital evidence examination and how the challenges faced by the investigator when collecting or even examining digital evidence before presented in court. The practical case studies, as well as the practical ways on how digital evidence are actually presented in the US court proceedings that some of us are really keen to know. So we get a first-hand experience shared by you today. I think our audience today, whether judges, judicial officers, as well as the public, from our discussion, they are undoubtedly will be better equipped on the knowledge of digital evidence. And as Trenson mentioned, then we have to work smarter and harder during this this time. The technology inevitable will be. I think in the future, in near future, our court will be handling with this type of cases more and more. So I think in the future, when the situation allow, we really would like to invite both of you again to do even longer session. But for today, thank you both of you very much that are here with us virtually. And once again, our gratitude extended to the U.S. Embassy, who have kindly coordinated both of you as speakers. On behalf of the Office of the Judiciary, Office of International Affairs, thank you once again to both of you for sharing with us and sparing your time this pandemic, and hoping you will keep safe and well, and we will certainly invite both of you again when the opportunity permits.
Thank you so much for inviting us.
Thank you, Honorable Pantowi. We appreciate the time and definitely enjoy working with you in your office. We as well learn a lot from our counterparts being overseas. So thank you very much, and be safe as well. สวัสดีครับ
สวัสดีค่ะ ขอบคุณค่ะ
ขอบคุณครับ